My name is Krajnyák and I was the organizer of this panel. For this panel, actually, I chose a little bit broad topic, but I would like to narrow it down because last year I was talking about the Hungarian constitutional framework, and I wouldn't like to repeat myself, but I know that most of you are going to talk about the national constitutional framework. So I will include the Hungarian one and then connect it to one very topical issue with regards to the interrelation of the protection of the environment and human rights. So first of all, about the Hungarian constitution. It was adopted in 2011 and it is in force since 2012, so it is a relatively new constitution. And it has a very strong dedication towards the protection of the environment. First and foremost, which is very important, is that the constitution declares the right to a healthy environment, which also appeared for the first time in the constitution that was adopted at a change of regime in 89. Not only does the Hungarian constitution declare the right to a healthy environment, but it also connects it to the right to health, as we can see. So in this case, in the case of the right to health, the protection of the environment serves as a state task, which contributes to the realization of the right to health. There are also very specific provisions in the Hungarian constitution with regards to the protection of the environment. That is, for example, the responsibility for the damage caused to the environment. It should be noted that the right of everyone to a healthy environment was explained and interpreted by the Hungarian Constitutional Court several times, but with regards to the damage, I wouldn't say that it was in detail explained. Yet it would be very interesting to know who does anyone mean in this sense, because it may not only relate to the state or to individual citizens, but the question is whether it could be related to non-state actors and corporations. And there is also the provision which is about the transport of pollutant waste, which is actually prohibited in the constitution, and this got regulated in the constitution because of an actual transport that happened from Germany, the waste that was deposited here. So it was the legislators' the strong approach to reject this sort of approach in the territory of Hungary. With regards to the right to health, I mentioned that the protection of the environment is part of it as a state task, but there is also the GMO-free agriculture regulated in the constitution, as well as the provision of healthy food and drinking water. We don't have a Slovenian participant in this panel, but for your information, it is really important that in the Slovenian constitution, the right to drinking water, safe drinking water, is declared. And in this case, it is not a right, but a state task that serves for the realization of this right. So it is implicitly somehow included in the Hungarian constitution. Another pillar which is really important for the protection of the environment, and it has a place in the Hungarian fundamental law, is the protection of future generations, which appears at several points in the constitution. These are the most important ones. And because of the shortage of time, I just would like to highlight Article P, which is about the protection of natural resources. And what is interesting is that the legislator also puts biodiversity there, which is also interpreted by the Constitutional Court from an ecocentric approach. So it is really important that the Hungarian fundamental law embraces environmental protection not only from the anthropocentric side, but also from the ecocentric side. The Constitution also declares that it is the obligation of the state and everyone to protect and maintain them and to preserve the natural resources for the future generations. And now it is again regulated in the Constitution that the Hungarian Ombudsman has two deputies. One of them is responsible for national minorities and the other one is responsible for future generations. And I wouldn't like to go into details, but it will be connected to the second part of my presentation. So the Hungarian Ombudsman has several tasks in connection with the protection of the environment as well as with future generations. He has domestic activities, he has a very strong influence on the practice of the Constitutional Court, not only as a contributor with amicus curiae, but also with as a petitioner in one case, and these constitutional decisions that I mentioned here are key ones for the interpretation of Article P that I mentioned here, and also for the right to a healthy environment. As for the international activities, we can say that the Ombudsman is part of the National Human Rights Institutions Network, and mainly he cooperates with UN institutions. And that is where I can link it with the international development. So a few weeks ago, I think less than a month ago, the General Comment number 26 was adopted, which is a comment to the Convention on the Rights of the Child, the New York Convention, and it is a UN treaty body that adopted it, the Committee on the Rights of the Child, to the UN Human Rights Treaty of the Rights of the Child. And it interprets the rights that are declared in this convention from a climate change and from an environmental perspective. I didn't list all of them, but some of them are here, the most important ones, let's say. And what is really the novelty and the importance of this general comment is that it recognizes the autonomous right to clean, healthy and sustainable environment, which is in line with the development of the UN with regards to the recognition of this right. So last year, actually 2 years ago, the UN Human Rights Council adopted a resolution, and then last year the UN General Assembly adopted the resolution about the recognition of the autonomous right to a clean, healthy and sustainable environment. And this general comment also recognizes this one as an inherent right to the rights that are enshrined in the convention that I listed here, especially part of the right to a high sustainable standard of health. As we could see, it is also connected in the Hungarian constitution and also in international law. The right to health and environment is connected, and also right to an adequate standard of living is also connected. So yes, and the general comment also embraces the substantive as well as the procedural elements of this right. So the procedural side, access to information, for example, participation in decision-making with regards to environmental issues. Even though it is considered as a milestone in this field, but there are some, I wouldn't say shortcomings, but some issues that are criticized by certain scholars. First of all, that the relation between children and future generations are not really elaborated in the general comment, and it is always a question in international law who actually belong to the category of future generations. Some scholars say this, some scholars say that. The UN Special Rapporteur on Human Rights and Environment has one position, but courts have a different position, so it is under discussion, let's say. And it would be important, for example, for the recognition of the standing before courts, let's say. And also the newest developments with regards to intergenerational equity in international law were not taken into account when drafting this general comment. So the Maastricht principles that were adopted this year in February, as well as the UN Declaration for Future Generations, which is under preparation. Nevertheless, it wasn't referred to. And how does it connect to Hungary? Well, there were several stakeholders, several institutions, also a lot of children that took part in the drafting of this general comment, so they could have their say in it. And as part of the national human rights institutions, the Hungarian Ombudsman for Future Generations also contributed with a report to this one. And that's why I wanted to put together and to highlight the specific Hungarian perspective to the recent developments with regards to climate change and human rights development. So there are four points that were pointed out by the Hungarian Ombudsman, and these ones rather concern the definition or the limitation between children and future generations, as well as the channelization of the intergenerational equity and different principles to this general comment. Actually, the principle of the precautionary principle is mentioned in the general comment, but there is no reference to the non-regression principle, which is very important for not only for environmental protection but also for climate change. In any case, I would like to end my presentation with a few recent developments that are taking place in international public law, and this will be more of a general perspective that will affect all countries. So first of all, I've made reference to the UN Declaration for Future Generations that is being prepared actually now. And there is also a draft general comment to sustainable development to the International Convention on Economic, Social and Cultural Rights. So it also may have an impact on the understanding of sustainable development and therefore the understanding of future generations from the perspective of second generation rights. And of course there are 3 pending advisory opinions before different courts. So one of them I put as the first one, the International Tribunal of the Law of the Sea, because the hearings actually already started, so I think they are ongoing even this week. If I'm not mistaken, they started last week. And also there is a pending advisory opinion before the Inter-American Court of Human Rights and the ICJ, the Vanuatu Initiative. And we can also mention the pending cases before the European Court of Human Rights that represent another perspective of the interrelation of human rights and climate change. And actually in the first case there will be the hearing next week, and in the second two the hearing already took place in Strasbourg in March. And what I would like to mention here briefly is that there is certainly a strategic perspective in all of these courts, let's say, proceedings, because each of them tries to exhaust what is the strength of the different courts. So for example, the Inter-American Court of Human Rights has a very strong role in issuing advisory opinions, and the European Court of Human Rights has a role, let's say, a very strong approach to the development of the interpretation of human rights as a living instrument. So we can say that they are targeting the strengths of the different courts. And we will see what is going to happen. And another point is what we really should talk about is the responsibility of non-state actors in the framework of human rights violations that cause environmental harm or even climate change. There are also certain tendencies. There was the case a few years ago decided by the Dutch Supreme Court, the Royal Dutch Shell case. And also there are currently several pending cases before different domestic courts. We will see how successful they will be and how much the Shell case will be taken into account in any case. So yes, I hope that next year we can talk about some of these results because they are really fascinating. And I would like to thank you very much for your attention.